Hey guys, welcome back to my channel. My name is Michelle and my channel is about luxury goods from the perspective of a former client advisor. So today we have a special guest with us. This is Daniel ShenSmith and his YouTube channel is called Black Belt Barrister. Do check him out. At the time of this recording, he has about 70,000 subscribers. He is a remarkable barrister. He uploads every single day. So I actually met Daniel in Daryl Eve's Facebook group, and I'm so glad we've connected. He's really helped me a lot through the YouTube process. Really honored that he invited me to do this broadcast with him today. So he's going to talk about what he knows about luxury brands from the legal perspective. He has some experience in actually going to court with one of the luxury houses. As most of you know, if you've been watching me, I used to work for Louis Vuitton, which is part of LVMH, Louis Vuitton Moet Hennessy. It is one of the biggest, I think, if not the biggest luxury houses in the world, run by Bernard Arnault, who I believe is now number 3 or 4 richest man in the world. They have a very litigious group of attorneys, and they are adamant and vigorously defend any claims, trademark claims, anyone that may use their logo, such as the hangover when they presented a Louis Vuitton duffel bag. Also brands like Louis Vuitton, which does dog toys. I mentioned in another video they actually lost against them. But for this reason, and I'm in the US, so people like to sue each other all the time, but you wouldn't really expect to win against some of these big corporations. Anyways, with that said, I'm going to let Daniel tell his story about his experience in court with one of these fashion houses. But first, go ahead and introduce yourself, Daniel, and what you do in the UK, and a little bit about you and your channel.
Sure. Well, I'm looking at the screen because I've got a camera and a screen here. So I'll look at the camera as I usually do when I do my videos. But in the UK, the legal system is a little bit different than it is in the US. In the US, you have attorneys. Here, we have what we call a split profession. So we have what we call solicitors and we have what we call barristers. And barristers, the easiest way to explain this is, typically, the barrister will advise on very discrete areas of law. They will draft documents that have to be absolutely right, and they will go to court to present the case. And solicitors, generally speaking, will handle the rest of the case, the running of the case, file documents in court, and so on. To put it in perspective, there are something in the region of 300,000 to 400,000 solicitors and only about 17,000 barristers. So barristers tend to be considered very much more specialist. And of those, only 6,000 or so can actually deal with members of the public or companies directly without using a solicitor in between. And when it comes to actually filing documents in court, there's only a few hundred barristers that can do that, and of which I am all of those. So I do all of that. So I came to this profession to help businesses because of my background in business, but you can see more about that on my channel if you want to check that out below, without boring you too much more. But I have been involved in many cases like this, and Michelle is absolutely right. Lots of these companies are very litigious, and most of the big companies, quite rightly, will defend their name vehemently, very fiercely, in almost every situation. So if there's any claim brought, or if there's any infringement or any potential infringement, such as the Hangover film, and companies will tend to bring a claim to defend their brand, or they will vigorously defend claims when someone wants to claim money back, a refund, and things like that. So I suggested to Michelle that I would tell us a bit of a story like this, which, without mentioning names, of course, but it's one of the world's largest luxury retail brands, and it was for a bag for over a couple of £1,000 worth of bags, so fairly expensive, not absolute top end, but certainly not and market entry level. And so this lady went into this shop and bought this as a gift, had a conversation, as most people do, with the shop assistant, and said, "If this is not suitable for my husband, may I bring it back?" And I'm sure most people have this kind of conversation. And sure enough, as you would expect, the sales assistant said, no problem, you can bring it back, you can exchange it, or you can refund it. We will accommodate you if you come back if it's not suitable. She didn't really examine the bag. She trusted that for that kind of money, it was going to be good enough quality. And for the brand that she bought it from, she assumed that it was just perfectly fine, and didn't really check it.
I just want to insert here. Usually it's like they give you a time period, whether it's 14 days or 30 days. So that's part is important.
I see. That's important because that sort of forms part of the story, because in the UK, certainly, it's slightly different if you buy online than if you buy in a store. There's slightly different rules. So very briefly, if you buy it online, you get 14 days to return it no matter what. It's called a cooling off period. You get a right, and it is an enshrined right as opposed to an option, within 30 days to return it if there's anything wrong with it. Most stores, as you're right, Michelle, most stores will offer this option to return it within so many days. They are not obliged to, certainly not in the UK, they're not obliged to. And the reason for that is if you go into a store, you have the opportunity to physically examine the thing and then take it away with you. They're not obliged to give you this, certainly not in the UK, not obliged to give you this cooling off period or this 30-day window to bring it back, because you've examined it. You've had that opportunity to examine it. So if there's nothing wrong with it and you take it away, that's it, unless there's a serious defect, so if it was an inherent fault with the product, then of course the manufacturer or the retailer, the person you're contracting with, is at fault and should replace it. Otherwise, there's no obligation to do that. So in this particular scenario, this lady, obviously spending this money, wanted to ensure that she had this option to return it and get her money back or exchange it if it wasn't suitable. So she took it back, she put it in a cupboard, and not very long afterwards, but a little while later, she gave it to her husband. He looked at it, examined it. He tried to put his things in it. It just wasn't big enough. They decided as a family they would go back to look for something else, something slightly bigger, more suitable. And initially, the shop assistant, when they went back, not the same one as the original salesperson, but the assistant, when they went back, said, no problem, we will exchange this for you. In fact, it was very slightly cheaper, so there was a refund as well. She said, but before I can authorize the exchange and the refund, I need to get the manager's approval. I'm sure, Michelle, that is a standard procedure to get a manager's approval for an exchange or a refund. I'm guessing most luxury retail brands would do that, right?
Yes, always. We needed approval from the manager or the supervisor. And one thing to note too, it had to be in usable, resellable condition. So yeah, that was another question people ask, is what happens to returns? Well, we can't actually take it unless we can resell it to someone. So that means that person isn't supposed to use it or tamper with it. And that's just what we're inspecting for when they come back with the return.
Indeed. And so that's the very thing that comes to the discussion here. So was it used? Was it in resaleable condition? And so that was the conversation that was had. But in this scenario, the manager came over and said, well, first of all, he vigorously examined this bag and pulled it around according to this family. The manager then said, this looks like it's been used. Now, the family didn't accept that because they hadn't used it. This conversation went back and forth for a while. Eventually, they left with the bag because the manager refused to accept it back. A little while later, being the price that it was, this lady didn't accept the fact that she was now stuck with this bag. So she filed a claim in what we call it will be the county court, but on the small claims track. I believe you have a small claims court, whereas we have the county court that hears what we call small claims. So the important thing for this story is that for the small claims track, for claims, and the wording is important, for claims not more than £10,000, i.e. £10,000 or under, you cannot ordinarily, emphasis on the word ordinarily, you cannot ordinarily claim back from the other party your legal fees other than the fixed costs being There is a cost to issue the claim in the first place. There is a cost to pay for the hearing itself, which is only a few £100. So all of which maybe £600 or £700 by the time you've paid all those fixed costs. Those you can claim back. Other fees you cannot normally, like you pay your lawyer, you cannot normally claim it back unless in very narrow situations, like the other side are making a threat against you, they fail to comply with the court orders, they fail to file their witness statements, they fail to file any evidence, or they are just late and things like this, or they don't turn up to court when they're supposed to and the court has to push it back a month until they do come in and things like this. So the important thing is that this company paid almost £9,000 to defend this claim, which was worth just over £2,000. All the while, there was never really any real possibility that they would get those fees back, even if they successfully defended the claim. So if the claim went all the way through to trial and this company won and the court said the lady was wrong, you take the bag away, you get no refund, the company would still not have got their legal fees unless they did something really wrong or behaved unreasonably under the rules, because there was a reasonable ground to bring this claim. She said that there was a term of the contract, which I'll come back to in a minute. But interestingly, in the defense to this claim, this company invited the court to invoke its case management powers to strike out this claim entirely and award costs, which is quite a draconian step. It means the claim no longer exists. And it's usually done when, as this company invited the court to do so, on the basis that there was no reasonable, arguable ground to bring the claim in the first place. Anyway, so we went to trial and I was instructed to represent this claimant lady in this case. And all the while knowing that my fees are not recoverable either. But it was a point of principle. This was a lot of money for a bag and they wanted the money back, frankly. So in court, long story short, the judge believed this lady and her family, and paraphrasing the judge said, I have no reason to believe or disbelieve rather this family in what they say. However, didn't quite accept what the manager had said. In other words, didn't accept that this bag had been used, didn't accept the evidence that had been put forward, and ordered a full refund of this bag. But the interesting thing I thought was the extent that the company would go to. Obviously, it would be right if the company had have been right in what they said. It would have been right to defend it, but even then, do the costs outweigh the claim? It's another issue for discussion, because even if it's a successfully defended claim, they wouldn't ordinarily get the costs back anyway.
What was the price of the bag again?
It was just over £2,000.
So that's in the US, it's about $2,500. But
yeah.
Spent about £9,000 to defend the case.
Yes.
So of course, why wouldn't they just refund the bag?
Yeah, so at today's calculation, £9,000 is about just over 12,000 US dollars. So it's quite a disproportionate amount. But my reason for thinking that this is an interesting story for you is that this is, by far, is it not unusual? Mm-hmm. Most companies will do this. Most companies will spend such money to defend such claims, or even bring such claims. These kind of luxury retail brands, they will spend apparently, £5,000, £10,000, £15,000 on these kind of claims to defend it. But so a question back to you then, Michelle. What would you think a typical reaction would be from a shop assistant or a manager if you had a consumer saying, can I bring it back? And they said, yes, of course you can. And they said, how long? You maybe said 30 days. And they said, right, well, I'm going to write it down and I'd like you to sign it to say that I can bring it back. What would the typical reaction be?
So, okay, when I work there and I work in the US, it actually states on the receipt what the policy is, that you have 30 days to return or exchange as long as it is an unused condition. For the people who've been watching my videos, there are a lot of people who try a lot of ways to return something after it's clearly been used. So in my experience, that does come down to the manager. Because I will say there are things that are like, oh gosh, well, maybe it's been used once. Maybe we know the client has used it once,
Mm,
um, but they're exchanging it instead of asking for money back, or they have a purchase history. So
mm,
some things like that, okay, we might let slide as long as the money is still kept within the store. But I
mm.
have seen too where two managers agreed to take back a pair of shoes that had lipstick on the laces because they claimed
Right.
that the soles weren't used. And then the associate who tried to sell the shoes, she had to relace the shoes. It's like, why is there lipstick? Well, actually, I've seen it once where there was a mother and daughter who had purchased a $5,000 bag and claimed they didn't use it. But I think in this case too, there was a lipstick mark inside. So the manager wasn't taking it back. Okay, so my question to you is, could you explain to us why this particular store manager refused the return?
Well, what was interesting about this case is because it was during the COVID pandemic and everything was on lockdown and courts and everything else were struggling to continue, the courts had to continue in one sense or another. So this particular trial was by telephone, which was very strange because ordinarily you can see somebody, you can see the reaction, you can point to a document and you see a subtle confusion or you see a subtle surprise, and you can, as an advocate, I want to say you use that. I don't mean in a disingenuous or dishonest way, but you certainly use the reaction to develop your argument and to press and to pry and to question in the certain ways. But obviously on the telephone, you can't do any of that because you can't see them. You can only hear what they say. And what was interesting is at the beginning, the judge in these cases by telephone, in any remote hearing, the judge would always open with, you must treat this just as seriously as though we were physically in court, which to me suggested that some people were not taking this seriously. And that was my impression, actually, for the most part at the beginning, because I had opponents just hanging up on the judge because they didn't like what the judge was saying. In this particular case was about the photographs. The store manager had said, these photographs have been printed, scanned, and sent to me, and they're black and white, they're on the screen. The screen's not very good. I can't really see the photographs. So I think, okay, I need to develop my argument here in a way that is convincing to the judge and not get the trial kicked later down the road. I thought about what had actually happened on the day and how these photographs came about. Now, these photographs came about in the store when everybody was there, and they took photographs at the time. So I said to this chap, I said, well, you are the manager of this store, yes? And he said, yes. I said, you've been the manager of this store for many years. He said, yes. I said, you're very familiar with the line of products that you sell. He said, yes. I said, and in particular, for the avoidance of doubt, you're familiar with this particular bag. He said, yes. I said, when they came into the store, they were there for several hours, or at least, in the company of you for several hours overall. He said, yes. The bag was there. He said, yes. So you had this bag there for many hours? He said, yes. And I said, and these photographs were taken whilst you were all in the store together? He said, yes. So you have these photographs yourself, a copy of them? He said, yes. I said, so it doesn't really matter that you can't see them now, does it? You know what these photographs show. And to this one, he wouldn't answer the question. He refused. And this back and forth went on for a while until the judge eventually said, can you please just answer the question, yes or no? I had to highlight the fact that he had been in the presence of this bag, and it was a moment that he would no doubt remember very vividly. So it didn't really matter. So I thought that was interesting.
That is funny. Having worked there, I know that we can tell when a customer is being genuine, when they're legitimately saying, like, I didn't use this bag. And we can tell when they're lying, when they've clearly used the bag. So most of the times we give the customer the benefit of the doubt. And It's also inspected before it leaves the store, but
Yeah.
it is up to the associate and the manager to inspect these pieces, because it does happen where I sold a pair of sunglasses once and I looked at it like I would never sell it in scratched condition, and the gal came back saying, I walked out of here scratched, and it was clear that she had worn them to a party or to a photo shoot or something, and was trying to come back crying that, oh, she didn't like them anymore.
Yeah. I mean, it's true to say that the company shouldn't just refund everything because it would be more expensive to fight the claim. That's true, of course. And I think it's, in a roundabout way, it is unfair to the company that it would cost so much to do that and not be recoverable. But that's the position with the rules at the moment. If the claim is not more than £10,000, ordinarily you cannot get those fees back. So it's a catch-22 for the company. Do you refund the customer even if you really don't believe them, knowing that you won't get the fees back when you fight it? What do you do? So it's difficult, but obviously in some cases they are genuine claims and it really hasn't been used, and so on. So it is a subjective thing. So that brings me probably to the final point with what people watching as a consumer should think about this. Again, this is from a UK perspective, but broadly speaking, the rule of law and the way things work should be fairly universal. As most lawyers internationally would agree, the rule of law is fairly international. So the way these things come to court, you've mentioned the word subjective many times. For those that are not familiar with what it means, I don't assume that everyone knows what these mean. Subjective is what the person thinks at the time, and objective is what a reasonable, ordinary, what they sometimes say, man off the street person would think. These scenarios, I think, are both subjective and objective. The subjective elements, what does the consumer think? What does the manager think? Those are the subjective elements. And then by the time you get to court, it is an objective assessment by the judge. If I were the judge, what do I think about what I hear? Evidence from the claimant, evidence from the defendant company. The way judges here often say it is, I prefer the evidence of the claimant or the defendant, or I find the evidence from the claimant more convincing, more persuasive, more consistent, more credible, these kind of words. So ultimately, if yours is a genuine, credible, consistent case, and your account and everything you say is generally credible and consistent, you're more likely to be believed. If someone is angry with the judge, or angry with the opponent, or just generally angry and frustrated, there's two types of angry. There's an angry because they are genuinely upset that they have to go through this process, and there's another kind which is they are generally an angry person and possibly not as credible. And all of these things are taken by very experienced judges to make that objective assessment as to what really happened and make what we call a finding of fact. And in my case, to sort of round that off, I remember the judge saying, I find as a question of fact that the conversation between this lady and the assistant was to the effect that she could bring this back, and he even compared it with several other shops. You know, you go almost anywhere, they agree you can bring it back. And I find as a question of fact that that was a term of the contract. She was allowed to bring it back. She did so. They hadn't used it. There was no reason to disbelieve them in what they said. So that's it. And he concluded the case. The defendant company obviously lost almost £9,000 defending this claim.
I'm glad you bring that up, of the objective versus subjective. I told about how some managers might let things go, but that doesn't mean that the consumer here in the US, it doesn't mean they are allowed to break the rules, because the rules are the rules. You have 30 days to return or exchange without using it. And I see a lot of abuse about that rule here in the US. People think the rules are very flexible. It's a very entitled attitude, which is kind of why I started the videos that I did about when you're buying luxury or you're buying anything from anybody, they expect the company to bend over backwards for them if they've used the bag for 5 years and don't like it anymore. But this is a very different case in which your client had not actually used the bag and was still within their return limits. So thank you. That was a very interesting story. I guess what would your advice be for viewers who find themselves in this position? Is it worth it to go to small claims court?
I would say absolutely, if you really believe that your claim is genuine, then you should go for it and use the rules and use the evidence. The warning I would say is, well, two warnings. One is make sure you get all of the evidence that you possibly can, all of the details, all of the facts, the timeline, the dates, who saw what, who said what, and remember, if it's a spoken term of the contract, who said it, what did they say in the precise words, where you were when they said it, and when, obviously. But the final warning is, if you genuinely are not being honest about it, and you are in a category where you have really bent the rules and you are outside of the 30 days and you just think that you can play the system to get the refund, just know that these companies are most likely, and quite rightly, will defend such claims at great cost and expense. And if you are in the wrong, it will come out in court. There is no hiding. It will come out. And then if you are found to be dishonest, then that might be one of the reasons the court does award these costs against you. And so that's my final warning.
And that's important. The genuine is key, because if you are wrong, that usually comes out in the store and you'll be denied. So don't try to cheat the system. So with that said, when my advice for the consumer, and I know in the past year, people have bought online because of COVID. So whenever I purchase anything online, I turn on my camera and I film myself doing an unboxing, whether that goes on YouTube or not. It's just for myself, so that if I find anything wrong with the product and the store manager wants to dispute that, then I have evidence. And that actually did happen with me for a pair of sunglasses that a store manager had ordered for me from another store. They came with like a big thumbprint on them and they were clearly dirty. They took it back because I took it back right away within the time that I received the package. They asked for proof of when the package was received, which I gave them. But luckily I didn't have to use the video, but I did have that like evidence just because I wasn't able to inspect it in the store. So that's my bit of advice too.
Yeah, that comes under my limb of evidence is everything. I literally take photographs of everything, and people think me paranoid, but the one time that I don't do it, I will need it. So again, this evidence is everything. I take photographs and I make documents of everything. So yeah.
Wonderful. I think this was very insightful. I'm really glad that your clients were able to get their money back because they were genuine about it. I think this topic brought up just a lot of points about just the rules of the corporation, the rules of the law, whether consumers are being genuine or not. You know, all of these rules are meant to benefit the consumer, but also to protect the corporation as well.
Yes.
So it's not that complicated. But anyways, I'm glad that your client was able to get their money back, because that's huge, because I do think they were violated by not being able to, by that corporation not honoring the contract.
Yeah, in this case, I believe they were right.
Thank you so much, Daniel, for joining us. And for all my viewers, I hope you check out his channel. I've learned so much just in sitting here, interview with a barrister, because we don't have barristers here in the US. Do not confuse them with baristas. That's from Starbucks, which we love too. We all love our baristas.
Yeah.
So
I do good coffee as well.
Thank you so much for the enlightenment.
Thank you for having me. Well, legal principles are fairly international, so the law itself might be different. The principles of law, the way to approach a case is very much universal. So I'm happy to help in that respect.
Awesome. Thank you guys so much for joining. If you enjoyed this content, let us know in the comments. Let us know if you run into any of these encounters. Thank you so much, Daniel. If you're to this point of the video, guys, thank you so much for watching. I know this was a rather lengthy story time, so I hope you got some value out of it. And thank you so much again for all your support with my channel. So don't forget to smash that like and subscribe button. Don't be a stranger. Be sure to come back. My name is Michelle. Bye.